So our demand today is very simple, that the provincial government amend the Workplace Safety and Insurance Act to remove the discriminatory age caps for older injured workers' loss of earning benefits at the Workplace Safety and Insurance Board. Specifically, amendments are required to Section 43 of the Act that state injured or ill workers only have access to WSIB LOE benefits until age 65 if the injury occurs under age 63, or for a maximum of 2 years if they experience injury or illness at age 63 or older. The law is clearly discriminatory and unfair. The Canadian Charter of Rights and Freedoms, Section 15, subsection 1, guarantees that every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination. Section 15 prohibits discrimination based on age, among other grounds. Section 43 of the Workplace Safety and Insurance Act violates the enshrined constitutional principle because it unequally impacts older workers by arbitrarily ending benefits based on age alone, assumes a one-size-fits-all retirement age, ignoring economic and social realities, and denies older workers equal access to the WSIB's income protections, a benefit younger injured workers retain until they can return to work or reach age 65. A brief history for context will explain how we arrived at this point. So prior to 1990, permanently injured workers received a pension for life. In 1990, the legislation was changed to a wage loss system for injuries from then to the present. Injuries resulting in permanent disability are compensated by loss of earning benefits to age 65 if the injury occurs under age 63, and workers injured at age 63 or older get a maximum of 2 years loss of earning benefits. In 1990, 65 was a logical endpoint for these benefits because mandatory retirement at age 65 was common practice. It was permitted by the Human Rights Code, which defined age as 18 to 64 years. However, by the early 2000s, mandatory retirement at age 65 had become very unpopular and governments were under pressure to legislate an end to it. In 2005, based off the Ontario Human Rights Commission decision that ruled mandatory retirement age was discriminatory, the Ontario government introduced Bill 211 to revamp laws on retirement age. Bill 211 came into force in 2007 with the provision that the age 65 related limits in the Workplace Safety and Insurance Act applied notwithstanding the Human Rights Code. Since then, we have not seen an interest by Ontario governments in removing this age discrimination provision. So essentially, there was a carve out, an exception made for the WSIB through the government legislation, which allowed the WSIB to continue to discriminate based off of age. So the age discrimination was challenged in 2008 as being contrary to the Canadian Charter of Rights and Freedoms. The government successfully defended the age 65 cutoff at the Workplace Safety and Insurance Appeals Tribunal, and the tribunal decision was upheld on judicial review by the Divisional Court. That's known as the Guthrie decision. Since that time, the participation of older workers in the labor force has increased significantly, and as a result, age 65 is no longer acceptable as a cutoff point for workers' compensation benefits. So Western Canada offers examples of more flexible and reasonable approaches to wage loss benefits for older injured workers. In British Columbia, if a worker is under the age of 63 at the time of their workplace injury, they can receive wage loss benefits until the later of either the date they turn 65 or the date that the worker would have retired after age 65 as determined by the Workers' Compensation Board. An injured worker has an opportunity to provide the board with evidence as to the date that they would have retired. And if a worker is older than 63, they can get benefits until the later of 2 years post-accident or the date the worker would have retired as determined by the compensation board. And in Alberta, the legislation defines the normal retirement age as 65 or 5 years after the date of injury, whichever comes later. A worker, again, has the opportunity to provide evidence to the board that they intended to work beyond the normal retirement date. We strongly urge the provincial government to use the approaches from BC and Alberta as a starting point to amend the discriminatory sections of the Act. Any legislative change must also include retroactive financial restitution for the injured workers who unfairly lost out on benefits because of the discriminatory nature of the existing law. My workplace, the Injured Workers Community Legal Clinic, and other legal clinics, along with lawyers from the private bar, have ongoing appeals at the WSIB with respect to the age limitation provisions. Our goal is to have the appeals heard at the tribunal in a batch appeal. If the tribunal does not accept the charter arguments, then my colleagues will proceed to divisional court. But with that being said, we would strongly urge the government to take action to remedy this discrimination now, rather than wait for this to proceed through the legal system, which will be costly and take years. The WSIB government may tell us that amending the Act is too costly. However, we know that the WSIB's financial position is the best it's ever been. The government likes to brag how it has saved business around $20 billion since first being elected, and average premium rates have declined from $2.35 to $1.25 in less than a decade. It's high time to prioritize and properly compensate those for whom the system is built, the injured workers. No further delays, amend the legislation now. Thank you.
Thanks, Chris. Our next speaker is John McKinnon, who's a lawyer with the Injured Workers Community Legal Clinic in Toronto, and he's going to provide us some information from Statistics Canada on older injured workers. John, go ahead.
Thank you, Jules. As Chris mentioned, the times are changing as far as the participation of older workers in the workforce, and we've all seen that. And it's our intention to commission a detailed expert report on the participation of older workers in the workforce to establish this. Is one of the things that we have to show in the legal challenge is that the times have changed since the divisional court looked at this 16 years ago. The data certainly that we see from Statistics Canada and from the WSIB shows very dramatic changes in the past just 15 to 25 years. There is a myth that I think we're aware of that older workers are somehow less productive than younger workers, but there's quite a bit of research done on that to date, and the research demonstrates that for most occupations, older workers are no less and no more productive than younger workers. So that's certainly a myth and is part of the ageism and discrimination that older workers face keeping and seeking employment. And as a result of the baby boom generation, there were a few people over the age of 65, relatively few in the population until really the past several years. A couple of numbers from Statistics Canada. Back in 1999, 12.5% of the population was aged 65 years and older. Look ahead to 2023, and 18.3% of the population is aged 65 and older. So that's about a 50% increase in recent years in terms of the number of people that are over age 65. And as Chris mentioned, the Ontario Divisional Court decided that age 65 was a reasonable age limit to limit benefits for lost earnings from a workplace injury. And that was based on the data that they had from 2008. Back in that time, the average retirement age for Canadians was 62.3. And back at that time, only about 14% of Canadians who were age 65 and older had some income from employment. But again, looking at Statistics Canada, the average age of retirement has increased. Now by 2023, for Canadians, it was age 65.1. So most workers are continuing to work past age 65. Another statistic in 2023, 30% of all Ontarians aged 65 and older were employed. So as I mentioned, that number was about 14% back when the divisional court looked at it, but now 30% of the of Ontarians aged 65 and older are employed, and if you multiply that 30% times the The workforce, that's 843,000 workers in Ontario over age 65, and their right to compensation for work-related injuries is cut short simply because of their age. And of course, as you would expect, with significantly more people working past age 65, there's going to be more workers injured at age 65 and older. And so we got some data from the WSIB back in 2009. So when the divisional court was looking at the age cutoff, the WSIB had 4,047 claims by workers aged 63 and older. So the number we have now, this is for 2024, it's for workers age 65 and older, so slightly smaller group in theory, but the number of claims in 2024 by workers age 65 and older was 16,698. That's more than a 400% increase in injured workers in Ontario over the last 15 years. And they're not adequately protected by our workers' compensation system. And I should also mention, and this is something that our expert will look at in more detail, but it's our view that this has significantly greater impact on racialized workers because racialized workers have less other resources to fall back on. Again, looking at the numbers in Statistics Canada's public reports, less than 40% of racialized people over the age of 65 have some kind of private retirement income, but nearly 70% of non-racialized people over the age of 65 do have some type of private retirement income. So racialized workers are under greater financial pressure to keep working past age 65, but if they're injured at work, they're not fully compensated for their loss of earnings. So in sum, research shows that a lot has changed regarding older workers in the workforce since the Ontario Divisional Court said that age limits in workers' comp based on age 65 were okay. It's not okay now. It's unfair discrimination, and that sends older injured workers deeper into poverty. So I'll stop now. Thank you, Jules.
Thanks, John. I'm gonna go back to Chris again, who's going to introduce us to three workers who are affected by this legislation. So Chris, take it away.
All right, thanks, Jules and John. So first, I'm going to just slide my computer over here to my client. His name is Brian Ellicott, and he is going to read a statement based off of how he's negatively been impacted by the age cutoff.
My name is Brian Ellicott. I worked in the bricklaying trade for more than 40 years. I helped build many of the infrastructure projects that you see across the province. Throughout my work life, I never experienced a work-related injury until a few years ago. However, I had always thought if I ever did get injured, that the WSIB would have my back. I found out the hard way that wasn't the case. On July 28th, 21, at the age of 63, I experienced a serious injury to my bilateral ankles and feet when I stepped on an overhanging scaffold plank and fell 2.5 meters to the ground. Because of the seriousness of the injury, I was unable to work, so I received loss of earning benefits and healthcare benefits from the WSIB. I have undergone 4 surgeries with the possibility of more in the future. Unable to return to my pre-injury job, the WSIB started to provide retraining in courses for mortgage agent licensing. While I was taking these courses, there were disruptions due to surgery on my work-related injuries. The surgery resulted in blood clots in my lungs, causing me to be on blood thinners for 6 months, and that happened with 2 of the surgeries. In July 23, the WSIB called me and explained that my LOE benefits would terminate on July 28th, 23, 2 years post-accident. as I was injured when I was 63 years of age. To add insult to injury, the WSIB also cut me off from the retraining program before I was finished. The WSIB decision to terminate my LOE benefits and end my retraining is unethical and immoral. In my opinion, this is clearly age discrimination and the law needs to change. I never expected to receive benefits for my life, for my whole life. What I did expect to receive was LOE benefits and retraining until I was recovered, retrained, and capable of working again. Throughout my life, I prioritized maintaining excellent health so I could continue working into my 70s to support my family financially, similar to some of my colleagues. I also wanted to continue working because I love what I do. Unfortunately, due to my injury and the unjust law, I have been without employment income since July 23.
All right. Thank you for that, Brian. And that's a, primary example of what happens to many older injured workers when they experience injury when they're 63 years of age or older. I'm also going to read two statements provided by two of my clients who also experienced age discrimination. So they're both not able to be here today because they're actually working. So the first client, his name is Juan Sonko. So the statement from Juan, good afternoon. My name is Juan Sonko, and I work as a bus operator. I was born in September 1958, and I was injured at age 63 on May 6, 2022. The injury occurred when I was on my way to the operator's washroom. A middle-aged woman ran toward me, asking for help as she was being harassed by a man. I tried to de-escalate the situation. However, the man vented his anger at me and started to yell. Sensing the woman might be endangered, I told her to leave the station right away. After she left, I continued on my way to the washroom and the man assaulted me. The WSIB approved my claim for a psychological injury and I received loss of earning and healthcare benefits. Because I was 63 at the time of the injury, the WSIB cut me off loss of earning benefits 2 years post-accident on May 6, 2024. While I was still in a graduated return to work program with my employer and while my PTSD had not resolved. I did not return to full-time regular hours until October 14th, 2024. This means that I lost out on income from May 6th, 2024 to October 13th, 2024, while I worked graduated hours. The WSIB said they cut me off because that's what the law and policy says. My employer refused to top me up for the wages that the WSIB otherwise would have paid, but for my age. During this 5-month period, I was short funds to pay my bills and daily expenses. I was even forced to borrow money from my sister to pay the basics. What happened to me is a big injustice. The policy of disqualifying older injured workers from loss of earning benefits is discriminatory. I was protecting a vulnerable woman from harm, and my reward was being cut off benefits prematurely because of my age. The provincial government and the WSIB should show some empathy, and they should not have left me out to dry. And that's the end of Juan's statement. Next, I'm going to read a statement from my client. His name is Alan Upshaw. Quote, my name is Alan Upshaw. I'm a maintenance worker at the TTC. I injured my left knee at work on September 8th, 2009. While descending from a scaffold, I slipped off the bar with my left foot, causing my left knee to twist and buckle, resulting in a meniscus tear. I received loss of earning and healthcare benefits from the WSIB. At the time of my injury, I was 52 years of age as I was born on September 1st, 1957. I required 5 medical procedures for my compensable left knee, most recently on March 30th, 2022, and on January 24th, 2025. The WSIB covered my healthcare expenses related to these procedures and my recovery without question. My age was not considered a factor when determining eligibility to healthcare benefits. Following the March 30th, 2022 surgery, I returned to work prematurely on August 27th, 2022, because my loss of earning benefits were set to expire on September 1st, 2022, when I turned 65. I needed to get back to work as I could not afford to lose income. I believe that my premature return to work contributed to my ongoing knee issues that resulted in another surgery on January 24th, 2025. Once again, the WSIB covered my healthcare costs related to the surgery and recovery. But because my initial injury occurred when I was under 63 years of age, I did not receive any loss of earning benefits when I was off from work following the 2025 surgery, as I was over 65 years of age. This does not make sense to me. The WSIB accepted the injury, the surgery, the treatments, and they acknowledged that I could not work while I recovered, yet they didn't pay me loss of earning benefits due to a discriminatory law. I returned to work on May 12, 2025. During my time off after the surgery, my source of income was sick benefits through work. The sick benefits did not pay at the same rate of WSIB benefits, so I ended up losing money. But most importantly, it should have been the WSIB paying me benefits that whole time, not the benefits through my work. The WSIB is essentially passing the buck. It surprised me to find out how the WSIB gets away with discriminating against older injured workers. The government needs to change the law so more people are not negatively impacted like I was. End quote for Mr. Upshaw. So those are three examples of my clients who have experienced this. I believe next on the agenda is Lois Cromarty, who's the executive director for the Northumberland Community Legal Clinic. And Lois will be speaking about one of her clients. So please go ahead, Lois.
Thanks, Chris. I'm honored that my client, Mary Cooper, has given me permission to share her story as an older injured worker. Mary was 56 when she broke her right shoulder in a workplace accident back in 2013. The fracture of that shoulder caused ongoing pain, permanent restrictions on the range of motion in her right shoulder and neck, as well as daily severe headaches. She has difficulty finding a comfortable position in which to sleep due to the pain and has taken to sleeping in a recliner because it's too painful to lay down. In the WSIB's eyes, Mary did all the right things after her injury. She returned to work shortly after the workplace accident as her employer accommodated her disabilities. This meant that she received less than 1 year's worth of loss of earnings benefits back then in 2013, which in turn meant that she would not receive a loss of retirement income benefit from the board when she turned 65. Because her injury resulted in a permanent impairment, she did get a non-economic loss assessment award. Mary is now over 65 and is still working at the modified work despite the pain she's enduring. In fact, she has now developed pain and dysfunction in the opposite shoulder due to overuse and over-reliance. Last year in 2024, Mary's specialist recommended that she undergo shoulder replacement surgery as the only means of giving her some permanent pain relief and improved function in her right shoulder. The estimated time of recovery from the surgery would require at least 6 weeks off of work. Even though successful surgery would relieve a great deal of her pain, Mary had to turn it down because she could not afford to lose time from work. Mary is the sole breadwinner in her family, supporting a disabled spouse. She needs and plans to work to at least age 70 and beyond, as there's no pension from her workplace to support old age security or supplement old age security and Canada Pension Plan benefits. Mind you, getting loss of earnings would still not fully restore her wage loss for the time off she would need for surgery, because, as was mentioned before, loss of earnings are only paid at 85% of take-home pay. That's a topic for another day that needs reform in the workers' compensation system. But the other option for income replacement while unable to work, like employment insurance benefits, would pay even less at 55% of net insurable earnings. The fact is, though, that Mary cannot get WSIB loss of earnings benefits because her situation is specifically excluded in one of the discriminatory age restrictions in the Workplace Safety and Insurance Act. Workers over age 63 will only get loss of earnings benefits if they suffer a new injury. This leaves Mary without loss of earnings benefits because she's over 65, and the injury that needs surgery now is one that happened 12 years ago. Mary worries that she will not be able to continue to work without the surgery. But without wage loss benefits from the WSIB for her recovery, she sees no other option but to continue on working in pain as long as she can. Her family's financial future depends on her ability to work. After continuing to work in pain, and with a medical solution in sight that requires time off work, the law denies Mary any WSIB wage loss benefits and discriminates against her because of her age. Thank you.
Thanks, Lois. I want to thank Brian for your presentation and also for Juan and Alan for their stories and Lois for presenting Mary's story. It's a sad situation that this is happening, and that's only 4 people. And as John said, John McKinnon mentioned, there's thousands of workers with the situation. It's a sad situation.
17.
We're now going to have some statements from our 2 host organizations. So our first speaker is going to be Janet Patterson from the Ontario Network of Injured Workers Groups. Janet?
Thanks, Jules. Prior to January 1 of 1990, workers, when they suffered either a permanent injury or an illness, they received a pension for life. January 1, 1990 brought around the end of that, and instead the WSIB introduced the loss of retirement income, so they invested 10% of the workers' 90% of their net earnings. That is the amount after the CPP has already been deducted. So at that time, the CPP was around 5% of the gross earnings, while the loss of retirement income was 10% of the 90%. Today, CPP is about 12% of gross pay. Loss of retirement income is 5% of the 85%. So what we're seeing is that workers, when they go to retire, the income is not there. And it just lands up, in many cases, it's more poverty for them. The reduction to 5% in the loss of earning retirement income happened in 1998, and that was when they talked about basically it was the unfunded liability. The WSIB was in financial distress. Well, many of us do not agree with that, but we know now that the WSIB, they not only eliminated the unfunded liability in record time, they decreased the employer premium rates in Ontario by roughly 2/3, and they've still amassed surplus dollars to the point that they are able to give returns to employers for their premiums in the billions of dollars every year. Furthermore, under the potential threat from the tariffs, the Ontario government, the premier, he announced that he was returning taxpayer dollars to the employers in the amount of, there was $2 billion and then a second $2 billion. Those monies came from the WSIB coffers. So they are not taxpayers' dollars. How the government has access to the taxpayer dollars to divert it in that manner is a question, another question for the day, of course. Since 2006, workers have had the opportunity to work after age 65. And a lot of people do. You know, I like my job. I've loved my job. We heard about it from Oh, I'm sorry, I'm terrible with names. The first fellow there. You know what? You enjoy your job. You like the routine of it. It gives you great benefits from working. And I don't mean, I'm talking about the intrinsic benefits as well. So you decide you want to still keep on working. However, workers who have suffered permanent injury or illness from their workplace, they don't have that choice. They don't have the ability to work. And when they reach the age 65, the LRI, the loss of retirement income, it does not equate what they would be receiving should they have been able to keep working all these years. So that means that they are now definitely put into a destitute spot. And the WSIB has the ability, they obviously have the money to be able to change this and to make it a fairer system for workers. And we sure hope that they will take another look at this and see how they make it fairer. Thank you.
Thanks, Janet. Our next presenter is Eugene Lefrancois, who is the president of the Thunder Bay District Injured Worker Support Group.
Okay, so you heard the stories, you heard the problems. Doug Ford, if you listen, we are challenging you to a debate. You can bring Jeff Lang along, because you guys don't do absolutely nothing for the injured workers. The last time we got close to the Premier's office, Wynne was in power. So we can't even talk to Jeff Lang. We can't talk to Pacini, because every decision comes to you. You are responsible, no one else. And you break the law, you steal the money. Oh, we'll make it legal though. We'll just make a law that, oh, we got to return all excess funds. If you can make that law, you can make a law that says, oh yeah, let's help injured workers at the same time. But do you? Nope. You are just, and like Janet just said, you're announcing WSIB money as tax money. That is totally wrong, Doug. I am so pissed off at you about. Let's go debate. Me and you. You know, we can debate up here. Come up in front of me. Great. Bring Jeff. Thank you.
Thanks, Eugene. Our next speaker is Lise Bourgeois, the NPP for Thunder Bay Superior North. Lise, go ahead.
Thank you very much, Jules. And I'm a critic for WSIB and injured workers. And first you might want to ask, why do we need a critic for WSIB? We haven't had one before. And we have realized just how important it is because there's so much injustice built into the way that WSIB operates right now. So today we're talking about retirement age. I would like the government to actually look around the legislature and the MPPs and see how old we are. Okay, they're people well into their 80s, working as MPPs. They're not stopping at age 65. Why should other people stop being taken seriously as workers from the age of 65 and then be cut off from those supports? So you know what's good for one ought to be good for all of us, right? Now there are many other problems with the WSIB. It used to be collective liability. And then at some point, and probably somebody here to put a date to that, it was changed to what a so-called experience rating. And that actually winds up functioning as a, when was that?
1983.
Wow. It winds up as an incentive not to report injuries in the workplace. Because instead of having a collective liability, and so something happens in your workplace, you're not going to be shut. I don't say that you're not going to be shut down. You have to deal with the injuries and try and improve safety on that basis. But financially, you would not be crippled. So that collective liability was very important. Now that it's an experience rating, then if you don't report any accidents, you get more of a refund back from at the end of the year. So why would you report your accidents if you could get away with not doing it? So you've created an incentive to suppress claims. And we know that that's happening. So that's one of many issues, and I don't want to take us too far away from the retirement issue, because you know, we've got a very specific ask that amends the legislation in a very specific way and addresses age discrimination. It's very clear, as I say, what's good for us at Queen's Park is good for everybody else. Let's get rid of that age discrimination. It's so obvious, and treat injured workers fairly. This is one important step that would, and why should people then get to age 65 and be facing more and more loss of income and facing poverty? Thank you.
Thanks, Lise. We'll now open the floor to anybody that has any questions. Now, Matt, I'll have to tell you, I can't see the screen. I don't see anybody that from where I am. So maybe you can sort of take over that part. Either Chris, you or Matt can recognize anybody that has questions. Go ahead.
If there's any questions, feel free to raise your hand, and the chat is now open as well. I'm seeing a question from Randy Toms, 93.1 The Border.
Hi there. Hope you can hear me well.
Yep.
During the presentation, I was doing a bunch of searching online, and I noticed other provinces have the same rules in place, stopping their benefits at 65. I guess with the ongoing efforts to try to change it in Ontario, how do you think you can be successful if there's already precedents in other provinces that do the same?
Well, one possible answer is that there's an association across Canada called the WSIB Federal Association. I think that's the official name. There's no injured workers on that. I think it's just the money people from WSIBs across the land. There's your answer. It's greed.
So just to be clear, if I understood your kind of statement and question correctly, it sounded like you were doing some research and you looked at other provincial legislation which amounted to something similar to what exists in Ontario. So you're right insofar as the majority of provinces do have something similar to Ontario. But there are two provinces that I referenced earlier that do have more progressive legislation on this age issue. BC, British Columbia, and also Alberta. So in those provinces, there are cutoff dates that are still in place. However, a worker can provide evidence to the compensation boards that they would have retired at a later date, and things that could be, submitted to those workers' compensation boards could be, a letter from their employer stating that, we intended to employ John until he was, say, 72 years old. It could be financial statements. There could be references to mortgage payments. So there is a process in both Alberta and BC for injured workers to extend the date on which they receive those loss of earning benefits. So it's just more flexible, and workers can demonstrate their intent to work beyond the legislative cutoffs.
I might just add one point, is that all the provinces adopted this wage law system, and at that time, mandatory retirement was legal. Employers were allowed to terminate people when they reached age 65, and they were allowed to refuse to hire somebody who was age 65 or older. And our social morals have changed, and we've now come to believe that that's unfair discrimination. And now all the provinces have eliminated mandatory retirement, and now they have to deal with the fallout of that in workers' compensation. And so, as Chris mentioned, it's an evolutionary process, but they've seen the light in British Columbia and Alberta, and we're hoping that Ontario will too.
Okay, that's a wrap for our media conference. I want to thank everybody for joining us today. The speakers, thank you very much. Eugene, Janet, Lise, Chris, and John, and Lois. Thank you all very much for your contributions, your input. And we hope to do this more. It's our goal to inform the public what is happening to injured workers, what is happening to the compensation system. So we're going to be coming back with more of these media conferences to inform the public what is happening. Thank you all very much for joining us. Bye now.
Thank you for looking at this.